professor at Osgoode Hall Law School in Toronto, Canada, and I was previously a professor at the London School of Economics in London. I'm a specialist in international investment law and investor-state arbitration. I would like to speak about the significance of the investment chapter of the TPP from an economic and financial point of view. These mechanisms of arbitration are very important because of how they limit the policy space of sovereign governments to make decisions about health, environment, local development, and so on. But there also is a very important economic and financial component. The main claim that is made about these treaties is that they are needed to attract foreign investment. Research that has emerged in the last 2 or 3 years based on surveys of foreign investors, their corporate executives, as well as surveys of political risk insurance agencies, the evidence is very clear that foreign investors rarely consider these treaties or arbitration mechanisms when they make their investment decisions. So the claim that these treaties are needed to attract foreign investment thus far is not supported by the evidence based on surveys of foreign investors themselves. The second point I'd like to make is, with this lack of evidence about the economic benefits of these arbitration mechanisms, on the other hand, there is mounting evidence of the serious financial risks that states undertake when they agree to these mechanisms. In a sense, these arbitration mechanisms are like a ticking time bomb for taxpayers, because you never know when a decision that your government plans to make will be disputed by especially a U.S. investor. U.S. investors use these mechanisms approximately in half of the cases. And so they are really the gorilla in the room in the case of the TPP. So for Malaysia, you may have other treaties that provide for these arbitration mechanisms, but to extend this to the treatment of U.S. investors as well as some of the other countries' investors in the TPP is a major change in approach. The problem is that we as researchers really don't know where the system is going. In the last few years, there have been some very surprising developments. Just over a year ago, Ecuador was ordered by arbitrators under one of these mechanisms to pay more than $2.3 billion to a U.S. oil company, based on, in my view, very dubious legal reasoning. In other recent cases, investors have used these. In other recent cases, investors have used these mechanisms to challenge financial measures adopted by the Belgian government in the face of the European financial crisis. These mechanisms have been used to attack decisions of local and state governments as well as federal governments. They have been used to challenge decisions of the Supreme Court or Constitutional Court of countries. And increasingly, we see third-party financiers, speculative hedge funds, law firms themselves, funding the claims against the state. All of this creates a very explosive environment. And to proceed with assuming that liability on behalf of the country and all of the risks that come with it, without clear evidence of the economic benefits, raises the question of whether that is not economically and financially the responsible decision for governments to take.